Hey everyone, Eric with the Office of Stewardship. Thank you for joining us again on this Lunch and Learn. This is a very, how would you want to say, probably not a pleasant topic to address, but it's a necessary topic. And I've invited Julie Haas, who is an attorney over in Pratt, a member of Sacred Heart Parish, to help us understand and make sure we have our I's dotted and our T's crossed when it comes to how we handle end-of-life issues. Julie, please take it away.
Thanks, Eric. Thanks for having me. And by all means, if anybody has any questions, just interrupt me at any time and we can address whatever your thoughts are. Well, estate planning is essentially creating a plan for a smooth transition and to transfer your property. By smooth transition, I mean like during your lifetime, if you get to the point where you don't want to or can't handle your property anymore and make your own decisions, then who are you going to appoint to do those things for you? And we want to make that as smooth as possible. And then transferring your assets, you can do it during your lifetime or at your death, but at some point it will go to somebody. And so it matters a lot for you to be the one deciding where everything goes. If you don't have this plan in place, a lot of times what happens is somebody else is making those decisions for you, whether it's a judge or it's your family and they're fighting. So the reason to do this kind of estate planning is to get everything in place so that everything just operates smoothly when and if that moment comes. I usually like to start with the state taxes because it's always on everybody's mind. And so I want to kind of put that to rest. The estate tax system is a tax on the transfer of your property, and it's the fair market value of your property. So that is assessed whether you give it during your lifetime or at your death. But now each and every person has a lifetime exemption of $15 million. So each and every person can transfer to whomever else up to $15 million before there's any tax problems, before you're taxed on it. So that kind of, if you're under the $15 million per person, so if you're married, it's $30 million. Don't worry about it. You don't need to worry about the tax problems or the tax issues, the estate tax. Some people call it the death tax. There's no death tax in Kansas anymore at all. So I'm only talking about the federal estate tax. So that doesn't affect a whole lot of us anymore. So I usually like to get that off the table so it's not on anybody's mind. For estate planning, there are three basic concepts on how you pass property to your heirs. And it all depends on the moment you die, how things are titled. So let me kind of break that down for you. There's three different ways to pass your property. And I'll go through these in detail, but the first is by contract. The second is by titling, and the third is by probate. So probate is the court proceeding. So if you have it, one of these other two ways, by contract or by titling, then you don't go through probate. You avoid probate. And so that's usually, for the most part, what our goal is in making this smooth is to just avoid probate. Don't have to go in front of a court. When you go in front of the court, it's all public knowledge. A lot of people don't like to have their balance sheet, if you will, their inventory, be a part of the public record. But also have the court involved and sticking their nose in the place where you don't want it to be. So let's go back then to the contract. By contract, I mean some company is contractually obligated to pay your property where you say you want it to go. And that is naming beneficiaries. Everybody has come across that. Life insurance, you name a beneficiary. 401k, IRA, those kind of things, you name a beneficiary. If you have a beneficiary name, it goes to that person, period. You don't go through court. You don't, nothing else happens. You just go to that company, you fill out their paperwork, and they transfer it to you. The second way is titling. Titling is a legal way of owning your assets. And usually the form that everybody's the most comfortable or most common is joint tenancy, like a husband and a wife own property in joint tenancy. That legally means that if one of you dies, the other one gets it all. And you don't have to go through probate, and you don't have to do anything else. You might ever, or you prove that that person died. You take the death certificate to the bank or wherever you have an account. Or like if it's joint tenancy in your house, you get the death certificate filed up at the register of deeds, and you've got clear title. And that's all you have to do if you own it in joint tenancy. You can also do a payable on death or a transfer on death. That has a legal meaning that it does not come into play until your death. So you can still, you are the one that owns the property, but you at your death, it triggers this payable on death beneficiary designation that person then gets it. So payable on death is common in a bank account or an investment account or a CD, those kind of things. You set up a CD or you open your bank account. The bank, people will say, do you want this payable on death to anybody? And if you put, if I put Eric is payable on death beneficiary, then the bank will pay it out to Eric. And it doesn't matter anything else that I've done. It doesn't matter that I'm married. It doesn't matter that my will might say something else, because it avoids probate. It avoids probate. And the will is only looked at if you go to probate. Okay. So that's one of the biggest concepts that people don't understand. I'll come back to that, but so if you have payable on death or transfer on death, that is a legal designation that makes it happen immediately upon death. Okay. Another common way to title your property is through a trust. And that entails you creating a document that says, this is, who I want to have handle my stuff. This is how I want it to go after my death. This is how I want it to go during my life if I'm incapacitated and can't otherwise direct or whatever. But we transfer ownership of everything you own into a trust. And then at the time you become incapacitated, your trustee just takes over, which again makes a nice smooth transition. And then at your death, the trustee just has to do whatever the document says. So we can build a whole lot of different scenarios or options in this trust. If somebody dies out of order, your kids die before you do, or something like that, or there's a minor, a 2-year-old that now just inherited some money. Well, what do we do with that? Well, we're going to hold it in trust until they're 25 or whatever it is. But the trust can encompass so many things, and that's why it's very popular and a lot of people use it. Okay, so back to bigger picture. So if you don't have the titling, which is that joint tenancy, the payable on death, using a trust, if you don't have that, and you don't have the beneficiary designations, like the naming your beneficiaries on a life insurance policy or a 401k or IRA, if you don't have any of that, then wherever you own that property, the bank or whoever, they're going to say, we're not doing anything until you go to court and the court tells us what to do. Go get yourself a court order. Otherwise, because they don't want to just hand it over to your kids. They don't know if that's what you would have wanted. So that triggers a court proceeding. And then somebody's appointed as the executor. And then they look and see if you have a will. Well, if you have a will and your will says, it all goes to my wife, my spouse, my husband, then that's what they do through the probate proceeding. But as turn you back around now, if I had my bank account payable on death to Eric, and yet my husband is in my will says it all goes to my husband. My will doesn't matter. If it's payable on death to Eric, it goes to Eric. You see that? You with me? Anybody have questions about that? That's usually the biggest, the misconception, that everybody thinks, well, I did my will, so my will is going to be how it goes. That's not true. If you have titled your property in some other way. Okay.
So if I understand you correctly, then would a bare minimum document be you need a will first, right? Or
Sure.
another kind of
Everybody
vehicle?
everybody needs a will, no matter what,
Okay.
because you need that backup. Because I can have my meeting with you and we decide, go get your CD named payable on death to your kids, go get your life insurance named to your wife, whatever it is you decide. And then 5 years from now, you sell that CD and you buy a different one and you don't do that again. You don't think to do that. So you still need this will as a backup that, that CD got missed. And so now they got to go through probate with that one CD. Well, your will says where it goes and you're good to go. So you do have a will, but it's a backup for whatever it is your other plan is, whatever it is you've decided on the titling of your assets.
Okay. So
Okay.
really, as homework, it would be wise to go and make sure that our accounts are designated the way we want them to be designated.
Yes.
I mean, that would be one of the first things we do as we begin this planning process is to check all those designations
Yes.
if we have them, of
The
course.
the risk you have in only doing the designations as compared to doing like a trust is somebody dies out of order. So for example, you've got kids, they're all adults now, and if you were widowed, you have payable on death to all three kids and you think you're good to go. Well, then you and your son are killed in the same accident. Well, now what happens? Does his 1/3 share go down to his kids, or does it just go to your other two kids? And there's no way to control that unless you have read the boilerplate language on that document at that bank. You see? So when someone dies out of order, or that's your risk in doing the payable on death, because you don't address all what happens if it doesn't go just the way I want it to go.
Okay.
And a lot of times that risk is just fine and everybody's perfectly good with going that route. But sometimes it's not a good way to go. It's much better to do a trust so that you can decide what happens in all those different scenarios. And somebody dies out of order, or somebody, whatever the situation may be. Somebody, right. Maybe your son got into it. You and your son were in the same wreck. He was just injured, but he survived. Well, now we don't want him inheriting money that then disqualifies him from getting some kind of benefit that he needs because he's disabled for the rest of his life. Something like that. All that stuff we can build into the trust. I don't mean to be selling a trust here. I just want to explain those are the good things about a trust that you can't get with just the titling. But titling is also a very good way to go.
And really, this is where somebody needs to sit down with a professional to see how complicated is my estate.
Yeah.
And then build out from what is the best vehicle to transfer my estate to somebody else, or what do I want to have happen? You got to sit down with a professional and wade through that, right?
Right. And it all depends on personalities too, because every person knows the personalities and the dynamics in their own family. And we just talk through that. If that's not going to work, then let's go a different route,
Right.
Okay. Yeah. Okay. So yeah, as far as key documents, everybody needs a will, no matter what you do. But then you plan this titling of your assets. and deciding on a trust or not. But the other documents that are absolutely critical are powers of attorney. And there are two different kinds. Usually people or attorneys split those up into two different concepts. One's financial and the other is healthcare. Fine. And basically a power of attorney is you deciding to allow somebody else to have legal or to make legal decisions for you and act on your behalf. It is a fiduciary duty, so they still have to do what's in your best interest. But if you have a power of attorney or these powers of attorney in place, then you avoid the need of going to court if you become incapacitated. So let me say that a different way. If you become incapacitated, you have a stroke or something, even if it's short term, and nobody can pay your bills, nobody can get into your bank account, nobody can, call your investment person to say, we need to pull some money out of the IRA to get it over to pay for the facility, the rehab facility, those kind of things. If nobody has that legal authority to do that, their only option for your family is to go to court and get a guardianship and conservatorship appointed. So these powers of attorney are very inexpensive documents that mean a lot and are really going to matter if something happens to you while you're living. But know that a power of attorney is only while you're living. So usually the concept is the power of attorney dies with you. And that's true other than your funeral. Whoever has your healthcare power of attorney can also make decisions on your funeral. And sometimes that really matters if you're talking about, a second marriage with kids, that don't agree with what the second spouse says or something like that. Whoever has that power of attorney legally has the right to do it. So I think financial healthcare or financial power of attorney kind of, just means anything that you can legally do for finances. Pay your bills, file your tax return, direct investments, sign a contract, all those kind of things. So you only want to appoint someone that you really trust because they're getting a lot of authority, a lot of legal authority, and you don't want to give legal authority to someone who might change what you wanted to have happen. Okay. Then there's the healthcare power of attorney, and it's the same concept. You're giving someone else that legal authority to make decisions for you. A lot of times people, my clients, want to give that power to more than one person. Like for example, you have 3 kids. You could have all 3 kids and your wife as healthcare power of attorney, and any one of them can act. That makes it so that any one of them can call the doctor and they'll release information or talk to them or whatever. That's not good for every family. Again, it's the dynamics of your own family, but I think it works well when you're talking about a family that has, there's no issues and you don't have to go through only one of you in order to get information from the doctor, that kind of thing. The other document, is there any questions about powers of attorney before I move on to the living will?
Nancy and Joanne, you're muted, so if you do want to have a question, you'll have to unmute.
Okay. Moving on then to the living will. It's the document everybody is familiar with it by calling it the turn the machine off document. It's kind of a tricky document, though. Not tricky, it's just hard to explain. It is a directive. It's a directive from you saying, if I'm in this spot, this is what I want you to do. And so it's not giving someone else that authority to make that decision for you. It is saying, this is what's going to happen. And my family needs to honor this decision. It's that kind of a document. I say that in the respect that that's the normal document. What I talk to my clients about, though, is, do you really want that? Do you really want your family to not have any legal way to say something different than what's on that document? If your family is sitting there saying, this, for me, this all came up at COVID time. If your family is saying, I don't want them taking you off the vent, I think we need a couple more weeks and see if she comes out of it. Well, they wouldn't be able to stop it if you have this document in place. Because again, it's a directive to the medical community. And so we talk through that. Who do you want from a legal standpoint? Who do you want to have the legal ability to have the final say? And depending on what the client wants there, some people still want that decision removed from their family's shoulders. Some people say, no, I want the family deciding. And don't get me wrong, 9 times out of the 10, the family's just listening to the doctors anyways. And everybody's in agreement. But if they're not, which is where my job as the attorney is to figure out, what do you want if they aren't in agreement. That's what we talk about. Who do you really want? Who's the bottom line should make this decision, your doctor or your family? But the other thing about this document, it does have a Catholic twist to it, and that is the feeding tubes and hydration tubes. Now, don't get me wrong, the whole turn the machine off document, or even starting the machine in the first place, has a Catholic element to it. And we are not required to do extraordinary means. We're not required to lay there on a machine for the rest of our lives. We're not. But when it comes to feeding and hydration tubes, it's a different analysis, or it's a different, it's a different analysis. The feeding tubes and hydration tubes are different because you could be laying there, some injured somehow in the mind, in the brain, so that you can't otherwise communicate, you can't eat, you're not getting up, you're not walking around, you're not doing any of that. And for whatever reason, they've already put the feeding tubes in. Okay. If you're laying there and you don't have any other reason that's going to cause your death, the Catholic teaching is, then it's not our decision to remove those feeding tubes. It's not. It's a pro-life argument of, we still see value in that life, and it's not up to us just to stop feeding you. So the Catholic teaching is, if removing those feeding tubes means your death is being caused solely by dehydration and malnutrition, then don't remove those feeding tubes. So in other words, if your liver is shutting down, if you got cancer, whatever it is, if that's what's going on and it's going to cause your death, there's no problem. Take the feeding tubes out. But if there's no other reason that's going to cause your death, then don't take those feeding tubes out. So that's the Catholic teaching on that. And I work that into all of my living wills. Does that make sense? It's a hard one to explain. Do you follow all that? Yeah.
Yeah,
Okay.
I got it. Yeah, that's
Yeah.
clear to me anyway.
Yeah. You may remember back in the late 90s, or I don't really know the age of anybody on here, but late 90s, early
Terry
2000s, there was
Schiavo.
that Terry Schiavo case. Yep.
Yeah.
Yep. And in law school, the concept was solely evidence of what Terry would have wanted. And so that's why everybody needs this living will. We need to have evidence of what you want. Well, as I got to actually getting out and practicing law and learn more about Terry Chavo, that's not what was at all. It was about this feeding tubes. She had laid there for 20 years with only feeding tubes. And the fight was that the family was Catholic and didn't want them removed, and the husband did. And he won. And so it was a tragic deal. So there's a website, you can go read about that if you want, but that's what's worked into the living will document. Now, let me also say this. Your healthcare power of attorney can already make all those decisions. Okay, so that's built into your healthcare power of attorney. Your healthcare power of attorney can make the decision to turn off the machine, to remove the feeding tubes, to even do a DNR in the first place. If you have a DNR in place, then they won't even put the machines on or put the feeding tubes in or start the machines if you already have that DNR in place. And your healthcare power of attorney can make that decision. So where it comes to the living will is, if you have that living will in place, then the doctors won't listen to you if you say, no, don't turn the machine off yet. So all that needs to be discussed thoroughly and vetted out and decided and worked into your documents. I guess that's all on my mind on the living will and the powers of attorney. I'll hesitate again. Anybody have any questions? Okay. Now to kind of move on to, I've already hit some of the common mistakes. One common mistake that I see a lot is clients walk in here and they say, I just named son Jimmy as the beneficiary of my life insurance, and I put him on my bank account as payable on death. It'll all go to him and he'll do the right thing. He'll share it with his 5 siblings. No, he won't. He will not do that. And I see it time and time again. They talk themselves out of it. Don't get me wrong. I know they're good people, and I don't mean to, because clearly I don't know these kids. I don't know these people, but they have no legal obligation to do that. And your other children have no legal way to force them to do that. And so it becomes a problem. And then you've created a terrible animosity now between you kids because they think he didn't do the right thing. And that's a fight. But the other element is, if you give it all to Jimmy, and it kind of depends on how much we're talking about here. If we're talking about $15,000 and Jimmy needs to go pay for the funeral for $12,000, okay, I can kind of see that being okay, and then if he doesn't share it, well, it's okay, whatever. But if we're talking about several $100,000, that's a completely different story, because now Jimmy, even if he does want to do the right thing, even if he does want to spread it out among his siblings, he is making a gift for gift tax purposes. And so, we need to discuss that and what Jimmy has in his estate, because he made that very first discussion that I had, that 15 million. He's only got 15 million or whatever it's going to be at that time that he can pass. And he's going to be using some of his exemption to pass to his siblings when he may need it for his own family, for his own assets and all that. So it's not necessarily just is he really going to do the right thing? He also has this other gift tax issue. So that's one of the big mistakes I see all the time, that people want to do that and they really shouldn't. I felt like there was a comment there, Eric. You were going, "Oh my gosh."
Well, yeah, exactly.
Does that make sense?
I had not thought about that because, yeah, if you put the entire bucket into one sibling,
Yep.
you've caused them a tax liability, and then it's got to spill over to the other three because they're going to
Yep.
pay tax on whatever gift Jimmy gives them, right?
Well, they don't pay tax. Jimmy has to pay the
Oh, he
tax.
pays it all himself. Okay, well done.
Yeah. Yeah, because it's a
Sure.
gift tax on the person who gives. But but the other thing is if it's a 401k, then Jimmy will pay the income tax on it when he takes it out. He will. And
Right.
it's gonna come on a 1099 to him, even if he does want to share it. So again, it's just not a good idea to do that. Um,
It's better to plan it out and have it be very specific on who gets what
right,
and how
right,
much. Right.
right. Um, the other common mistake that I see is saying to the kids or to one kid, I want it to go this way, and then you don't put it into any kind of legal document. So after death, when the kid comes and says, but she said, I get these things. I get this piece of ground, and
Yeah.
my sibling's supposed to get that other piece of ground. And it's not anywhere legal. There is nothing we can do about it. There is absolutely nothing we can do about it other than just the kids agreeing. And 9 times out of 10, the kids say, no, they didn't. They never told me that. Why would I agree to not take what I'm rightfully owed? So that's a big problem too. If you are saying, now don't get me wrong, if you're saying something and you really don't mean to have it in place that way, that's fine. But it's got to be on a legal document, and that's how it's going to be after your death.
Wow. Okay.
Yeah. So did I cover everything? I'm looking at my outline, seeing if
I think
um
you've given us a really good 1,000-foot view, Julie. You know, I think the precedent you've laid before us is that we can't assume the people we love will always do the right thing, and that if it isn't in legal terms, it really doesn't count. Would that be fair to say?
absolutely.
Okay, so that is our
Absolutely.
homework, is to
Yeah.
ensure that anything we want, medically speaking, financially speaking, we need to put in black and white and make it not just put it on, but then we need to have it run through an attorney or at least a notary public, right?
Well, yeah, everything needs a notary public, but notaries aren't going to be able to advise you and talk through all this
Well,
kind
that's
of
right.
issue.
But they would make the
Right.
document legal. But
Yeah.
as you just said,
There's a lot more to it. And
exactly.
and talking through it and figuring out the dynamics of your family is very relevant.
Right,
And
right,
we can make it very simple, or you can do things that you think are going to be simple that really cause a problem. So it just the process is, you come into an estate planning attorney and you spend a few $1,000s and you get things in place and it goes much more smoothly. Um, or if you don't do that, then you're looking at court, whether
court
whether
fees.
it's during your lifetime and you've become incapacitated, you got to go to court, or you haven't done the planning and you don't have things titled right and you got to go through court for your estate. Either way, that's significantly more than just a few $1,000s to get it all set up and ready with an attorney.
Right, right. Awesome. Nancy and Joanne, if you have questions, now is a great time to ask. We'll wait a few seconds here. You have to unmute, of course, or you can put it in the chat, and we'll wait just a few seconds here if you have something you want to ask.
Not anything to ask, but thank you very much for all your information.
You're welcome.
If they want to work with you or ask you further questions, how do they reach you, Julie?
You're welcome to call my office, 620-672-9446. I'm in Pratt. Of course, we're on the internet and all that stuff too, but that's the best way. Yeah, we need a lot more estate planning attorneys out here in Western Kansas. I'll say that.
All right.
Yeah. So I like doing these kind of things because I want people to know this information, even if
Right.
it just leads them down to the bank to get the beneficiaries named. If you have a simple estate, like a lot of people do, a 401k, a house, a car, a bank account, it can be very simple. Get down to the bank, get your payable on death beneficiaries named, get your beneficiaries named at your 401k. Your house, we can even do what's called a transfer on death deed, so that at the death of both spouses, it goes to the kids. And you do something like that, and they don't have to go to probate. The kids just get your death certificate recorded up at the Register of Deeds, and they sell your house and take the proceeds, and they're good to go. So, I want these concepts to be out there to understand that it can be very, very smooth rather than what the other route of not doing all those things. And then either it's all public or there's a fight.
Yeah, it
Either
causes
way.
dysfunction.
Yeah.
Yeah.
Right.
Okay, cool.
Okay.
Julie, appreciate your time. Man, it's just been a good thing. Like I said before, probably not the most joyous topic to concern ourselves with, but as good stewards, we have to steward our entire life, and this is a part of
Yeah.
it. So thank you for
Yeah.
your expertise. Appreciate it. There will be a replay go out tomorrow or the next day. So if you wanted to hear this again, or maybe you missed something, listen to it again.
Not at all. That's scary. It's a little scary.
All right. Thanks
Okay.
again,
Thank
Julie.
you.
Everyone,
All
we'll
right.
talk to you
Take care.
again.